I'd like to begin by reading our office's mission statement. The employees of the San Diego District Attorney, in partnership with the community we serve, are dedicated to the pursuit of truth, justice, and protection of the innocent and the prevention of crime through the vigorous and professional prosecution of those who violate the law. Notice the statement includes the protection of the innocent. Today, we continue to acknowledge that mission by announcing the formation of the George Woody Clark Conviction Review Unit. And we're pleased to have some of Woody's family here in the audience. We all knew Woody very well, and we all knew him for a lot of his work, particularly in the O.J. Simpson case, where he became famous. But it's because he and Lisa Weinreb, who was here to my right, who began the project with Woody, and it was nationally recognized to proactively initiate the kind of work that you're going to hear about today. With this unit, our office is formalizing efforts already in place to protect the innocent. And we're increasing our commitment to that ethical ideal. And its name implies the unit will review convictions in cases where credible and verifiable evidence of innocence exists. That includes new technology that can be used to test or retesting remaining evidence. We're prosecutors, and as such, we do justice by vigorously prosecuting those who violate the law. We also do justice by protecting the innocent in our search for the truth before, during, and after a conviction. As I mentioned, this unit formalizes work we've already been doing for quite some time. In fact, the San Diego DA's office has been a national leader in the area of post-conviction review for more than 15 years. And as a matter of fact, has received numerous awards for that after 2000, when it began under Paul Pfingst. In 2000, for example, we sent letters to hundreds of defendants in prison offering to test DNA evidence in their closed cases. Both Woody Clark and Deputy DA Lisa Weinreb were a part of that effort. We were also one of the first prosecutorial offices in the nation with a program that tracks DNA hits using our own electronic case management system. That program makes it possible to discover a wrongful conviction when a DNA hit belongs to someone other than the individual being prosecuted. We're fortunate in San Diego County, we have excellent access to evidence. For example, if someone calls and asks if fingernail scraping evidence is available from a closed case, we can find out and start the process of determining if a conviction review is appropriate. So in that sense, the Conviction Review Unit is nothing new. What is new, though, is the ability of the public to have improved and unprecedented communication directly with our office on claims of innocence. The public, the attorneys, or convicted persons can now apply to have a conviction reviewed via our public website, sandiegoda.com. The page has also been translated into Spanish. Here's how it works. Claims of innocence must meet the following prerequisites. The conviction must have occurred in San Diego County Superior Court. The applicant must still be in custody, serving time on the sentence for which he or she was convicted. The conviction must be for a violent and/or serious felony such as murder, rape, or robbery. The application for review must be based on credible and verifiable evidence of innocence. And last, the applicant agrees to fully cooperate with the District Attorney's Office, which includes providing disclosure of all relevant information during the review process. Applications will be accepted in writing only via fax or email. Our office is one of many across the nation that now have formal conviction review units. We recognize that despite our goal of pursuing justice and truth, in a few instances, new evidence is discovered, and in some cases, mistakes are found. As prosecutors, our legal, moral, and ethical obligation is to ensure that the right person is convicted for the crime charged. In the past several years, we have released 2 defendants who were serving a prison term, and just as importantly, we have dismissed dozens of cases in the interest of justice while they were making their way through the system. It's important to understand that the number of exonerations is low, in large part because we do not wait for a conviction in order to examine a claim of innocence. If at any time during the life of a criminal case we develop reasonable doubt as to the charges and whether the person is guilty, we dismiss the case. We generally handle these issues long before a conviction even occurs. What we do is part of our mission statement, and that is to protect the innocent as well. And I'm very proud of that.